In honor of Fair Housing Month, let's take a few minutes to review some of the basics of the Fair Housing Act. On April 10, 1968, Congress passed the Fair Housing Act to start the long process of trying to ensure fair housing throughout the United States. The goals of the Act were to define what constitutes unlawful housing discrimination and to outlaw those practices, as well as to reverse decades of housing segregation practices. President Lyndon Johnson signed the Act into law the following day, on April 11th. It passed 1 week after the assassination of Dr. Martin Luther King Jr. This is why April is Fair Housing Month. Fair housing under the law means that a person's eligibility for housing should not depend on arbitrary characteristics like race, color, or religion. The Act tries to reach this goal by prohibiting most participants in the housing and rental markets from making decisions or taking negative actions based on those inherent characteristics of a person. So what does it protect? When initially passed, the Fair Housing Act originally covered only discrimination based on race, color, religion, and national origin. Today it covers 7 characteristics. Those are race, color, religion, national origin, as well as sex, familial status, and disability. In other words, if you're looking to buy or rent a dwelling, you cannot be treated worse than others because you share one of those 7 characteristics. Recent court decisions have made clear that gender identity and sexual orientation are also protected under the umbrella of sex discrimination. Who must comply with the Federal Housing Act? Well, the Act covers more than just property sellers and landlords. It covers a wide variety of housing market actors, such as individual persons, corporations and associations, property owners, property managers. It also covers homeowners and condo associations, lenders, real estate agents, and brokers. But it doesn't apply to everybody. It doesn't apply, for example, to private individuals who are selling or renting homes where they own no more than 3 single-family homes. Now, for private persons selling a second home that they didn't live in, the exemption applies only to one such sale in a 24-month period. Single-family homes that are rented or sold to be exempt from the Fair Housing Act also may not use the services of a real estate broker, agent, salesman, or the facilities or services of any other person in the business of selling or renting a dwelling. If they do use such services, they are subject to the Act. Furthermore, individuals who might be exempt may not publish, post, mail any advertisement that violates the Act by making a discriminatory statement. Other exemptions apply to owners who occupy their own home and who rent out no more than 4 rooms or units to other families. Other exemptions include members-only private clubs and private organizations. So what type of discrimination does the Act prohibit? We talked about the 7 different classes, but the Act prohibits intentional discrimination as well as unintentional discrimination. Intentional discrimination is called disparate treatment, and this occurs when somebody treats a renter or potential home buyer adversely because of their status in one of the protected classes. Examples of intentional violations in the home renting or selling context can include the refusal to rent housing at all or sell housing or even to negotiate for housing. The discrimination can also include making housing unavailable or lying about the availability of that housing. It can also include establishing different terms or conditions for the sale of the home or the rental of the home. Or it can include providing different amenities or accommodations in housing based on the protected characteristics. Disability discrimination includes a landlord's refusal to make a reasonable accommodation to rules, policies, practices, or services where doing so is necessary to enable a disabled person an equal opportunity as a non-disabled person to enjoy the dwelling. Other examples of intentional housing discrimination include evicting a tenant or prohibiting a tenant from having a guest based on one of the protected characteristics, harassing a person based on those characteristics, the failure or delay in performing maintenance requests, or limiting privileges such as access to common areas, things like a pool or perhaps a playground. In the mortgage lending context, unlawful discrimination can take the form of refusing to make a mortgage loan to an individual based on one of the protected characteristics, or setting different terms or conditions on a mortgage loan, such as a higher interest rate or higher fees, or setting different requirements for making that loan, such as increasing the amount of income a person must have to qualify for a loan. Other illegalities that the Fair Housing Act prohibits include making discriminatory statements or creating advertisements that show a preference for or against a person based on one of the protected characteristics. Even people who are otherwise exempt from the Fair Housing Act are not allowed to make or publish discriminatory statements or advertisements. Individuals also may not threaten or interfere with somebody exercising his or her fair housing rights, nor may they retaliate against somebody who has exercised their fair housing rights. Those are some examples of intentional discrimination that is unlawful under the Fair Housing Act. Now let's talk about unintentional discrimination. The law calls that disparate impact discrimination, and that occurs when there's an action or a policy that creates a discriminatory effect even if there was no intent to discriminate in the first place. The action or policy has to have a harsher effect on people that are in the protected class than is representative of them in the general population. An example might be excluding potential tenants on the basis of them having had an arrest record. This has a disparate impact because racial minorities and ethnic minorities face disproportionately higher rates of arrest and incarceration. And as the Department of Housing and Urban Development has noted, such a policy does not serve a legitimate, non-discriminatory interest because arrests are not proof of past unlawful conduct. Who enforces the Fair Housing Act? Well, the Department of Housing and Urban Development is the agency tasked with enforcing the act. Within the department, the Office of Fair Housing and Equal Opportunity is charged with investigating complaints of discrimination that are filed with HUD. Complaints can be filed on HUD's website or by contacting HUD over the telephone or by downloading, filling out, and mailing in a form that HUD has on its website. It's also important to know that there are a number of state agencies in the various states, including in South Carolina, that also enforce state laws that require fair housing. And these state laws typically mirror the Fair Housing Act. In South Carolina, the state agency is called the South Carolina Human Affairs Commission. The Fair Housing Act remains a vital pillar of support for ensuring equitable access to housing for all Americans. I hope this information gives you a basic understanding of the Act.